response to great uncertainty which EU nationals and their loved ones currently experience due to Brexit, and on numerous requests of my subscribers, I've created this special Your Rights to Remain in the UK After Brexit video series, clearly explaining your immigration rights to remain in the UK and lifting this veil of uncertainty off your shoulders. Hello, my dearest friends. My name is Svetlana Shlapak. I am the creator of this free ukvisasuccess.com channel and also a senior immigration solicitor based in London, UK. I won my first UK immigration law case at the tribunal back in 2003, which gives me over 15 years of experience in the UK immigration law field. I'm here to explain how the UK immigration system works and empower you by helping you gain control over your immigration situation and explain how you can apply information in these videos in practice. I've created a special mind map outlining how EU nationals and their family members can check if they qualify for indefinite leave to remain in the UK. This mind map is accompanied by the PDF guide clearly explaining each element of the mind map. These documents are completely free and can be used in less than 60 seconds. All you have to do is click the link below. Okay, now let us have a look at your next question. Who can apply for indefinite leave to remain as a relevant EU citizen or their family member? Indefinite leave to remain, also known as ILR, is a document confirming the holder's right to remain in the UK indefinitely. If you're a spouse of a British citizen, you can apply for British citizenship immediately after receiving your ILR. And if you're not a spouse of a British citizen and you have this indefinite leave to remain document, then you can apply in 12 months' time, provided, of course, you meet all other requirements. There are actually 7 categories of EU nationals and their family members who can become eligible to apply for indefinite leave to remain in the UK. And here they are. Category number 1, the applicant is a relevant EU citizen. The applicant is a relevant EU citizen or a family member of a relevant EU citizen or a family member who has retained their right to residence in the UK by the virtue of the relationship with a relevant EU citizen. And the applicant has a documented right of permanent residence and no supervening event has occurred. Now, let me explain a few legal terms to you. First of all, the applicant is a person who makes an application, pretty obvious, but I thought you should know about this. Secondly, relevant EU citizen. A relevant EU citizen is an EU citizen resident in the UK for a continuous qualifying period which began before the specified date. And what is the specified date? Well, according to the withdrawal agreement, the specified date is 31st of December 2020. Supervening event. This event occurs when a person has been absent from the UK for more than 5 years, or there was a decision to exclude or remove or deport a person from the UK. Category number 2 is where the applicant is a relevant EU citizen or a family member of the relevant EU citizen or someone with the retained right of residence in the UK, and they have a valid evidence of their indefinite leave to remain or enter the UK. The only difference between permanent residence and indefinite leave to remain is in the fact that permanent residence is a right given to the relevant EU national or their family member under the EU law, and the indefinite leave to remain is the right to remain in the UK indefinitely given under domestic law, given under immigration rules. Category number 3, the applicant is a relevant EU citizen or a family member of thereof or a family member with the retained right of residence, and the applicant has completed a continuous qualifying period of 5 years in any of those categories or in a combination of those categories, and since then no supervening event has occurred. Category number 4, the applicant is a relevant EU citizen who has ceased activity, and since then no supervening event has occurred. Category number 5 is for family members of the relevant EU citizen who has ceased activity, and the relevant EU citizen has been or is being granted indefinite leave to remain under these rules for indefinite leave to remain, or they would be granted that leave if they made a valid application. And paragraph A applies was met at the point at which the relevant EU citizen became a person who ceased activity. In other words, where you were already a family member of a citizen when he stopped working, when he ceased activity. And the last condition is, since the relevant EU citizen became a person who ceased activity, no supervening event has occurred. Category number 6, the applicant is a family member of a relevant EU citizen who has died, and the relevant EU citizen was resident in the UK as a worker or self-employed person at the time of death, and the relevant EU citizen was a resident in the UK for a continuous period of at least 2 years before dying, unless his or her death occurred as a result of accident at work or some occupational disease. And the last condition in this category is that the applicant was resident in the UK with a relevant EU citizen immediately before their death, and since then no supervening event has occurred. Category number 7, the applicant is a child under the age of 21 of the relevant EU citizen or their spouse or civil partner, and either the marriage was contracted or the civil partnership was formed before the specified date, and we already know what the specified date is, or the person who is now their spouse or civil partner was the durable partner of the relevant EU citizen before the specified date, and the partnership remained durable at the specified date, and the relevant EU citizen, or as the case may be, their spouse or civil partner, has been or is being granted indefinite leave to remain under these rules. And well, this is it. These were 7 categories of EU nationals and their family members who can apply for indefinite leave to remain under the EU settlement scheme. What I realized when analyzing these rules is that the greater part of these new rules just mirrors the old rules for getting permanent residence. And by the way, they are not old rules as yet. It's currently good law, still applies, and will only stop being good law when expressly cancelled by the Home Office. And I do not expect this to happen until at least 29th of March 2019. And I also think that it will continue to be a good law until the UK government is satisfied that the new rules do work and give the protection of EU nationals and their family members as intended and as reflected in the withdrawal agreement. And if you do not currently qualify under any of the categories which I've just described, check my other videos where I explain the rules you need to meet in order to qualify for your pre-settled status. And just to remind you once again that a free mind map together with the PDF guides are available for you to download. These documents give you a bird's eye view of how EU citizens and their family members can remain and settle in the UK after Brexit. These documents are completely free and you can download them by clicking the link below this video. Have a great day, everyone.